Assalamualaikum and hello for Sahabat Rule. So today we're going to present about case study law and we are from section 1. Okay, so my name is Akil Harith bin Mahsan. My ID is KNJ 2005 10121. Okay, so for question 1, Ali and group of other workers intend to set up trade union in their workplace. However, in one of the provision in a contract of employment state that any employee are prohibited from establishing trade union at their place of work or participating in any existing trade union. Can the provision be included in the agreement? Consequently, most of the employees have changed their mind and cancelled the intention to establish trade union. Ali and 5 others workers on establishing trade union as they had previously agreed. Is the trade union registration process still possible? Advise Ali on the board matters. So for the answer for the first issue is whether that provision can be included in the contract of agreement. In my opinion, that provision cannot be included in the contract of employment agreement. To support my opinion, according to Section 5 of the Industrial Relations Act, it states that, firstly, no employer shall prevent a worker from joining a union by putting a condition in his contract of employment. Secondly, no employer shall refuse to employ a worker on the ground he is trade union member or officer. Thirdly, no employer shall discriminate against a worker. Example, in terms of promotion on the ground, he is a trade union member or officer. And then lastly, no worker shall be threatened with dismissal or dismissed if he proposed to join a trade union or if he participates in union activity. Okay, so in application, that provision cannot be included in the contract of service agreement or contract of employment agreement because it is against the provision in the Industrial Relations Act or it is against a law. As a conclusion, that provision cannot be included in the contract of employment agreement.
Assalamualaikum and hi, I am a second presenter. My name is Daniel Ashraf bin Muhammad Saleh. So the second issue is whether of the registration of the trade union is still possible. In my opinion, the registration of the trade union is not possible. To support my opinion, there are a few requirements to register the trade union. So the firstly is workers wishing to form a trade union must apply to the Director General of Trade Union for registration within 1 month of establishing the union. If the period of 1 month is insufficient, a request for an extension of up to 6 months can be made to the Director General. Secondly is the application for registration must be signed by at least 7 members, which is the minimum number needed to form a union. Thirdly, the application form must be accompanied by the required fees and a printed copy of the rules or constitution of the union. And finally is the application must include the name of the union and its address, the names, address and occupations of the members, making the application and the names, address, age and occupations of the union's official. The Department of the Trade Union may also require other information such as a copy of a minutes of the inaugural meeting of the workers who wish to establish the union. In application, the trade union cannot be registered because it not meets the requirements of the minimum members to apply for the registration. As a conclusion, the trade union cannot be registered at this moment.
Okay, before I start, I'm going to introduce myself first. My name is Aya Saidan Nafisa binti Rizwan. So I'm going to present question B. So the question is, with relevant examples, explain any 4 reasons for the distinction between a contract of service and contract for service. So this is the definition of contract of service. Contract of service specifies the employer-employee relationship as well as the terms and conditions of employment. Key employment terms and important provisions such as working hours and job scope must be included in the contract. Contract of service also an agreement whereby one person, which is employer, agrees to employ another and as employee. It might take the form of a letter of appointment, or it can take the shape of an apprenticeship agreement. In addition, the contract should be in writing to avoid the disagreement for terms and conditions. Next is contract for service. Contract for service is a legal agreement in which a service provider commits to deliver a service to a client in exchange for money. Following that, a contract for services can be entered into either orally or in writing. It is nevertheless a good idea to get everything in writing. If there are any issues, it will be much more easier to establish what the contract states. A contract for services, once signed, creates rights and duties for both the service provider and the customer. So this is the first reason. The first reason is compulsory statutory contributions and payments. For example, the Provident Fund, next Social Security, and also workmen's compensation and pension scheme are payable by employers if the workers are employed. The second reason of distinction of contract of service and contract for service is, in torts, an employer will not normally be vicariously liable for the tortious act committed by independent contractor, whereas the employer would be liable for torts committed by his employees in the course of them. For example, slip and fall accident and also car accident.
So, hello and Assalamualaikum. I'm Aina Ashila binti Kamal Zuhairi. I'm the last presenter. My ID number is KNJ 2005101117. So, I'm going to share the answer for question number 2, which is the reason for the distinction between a contract of service and contract for service. So, the third reason is an employer owes a duty to his employees to take reasonable care for their safety, whereas these duties do not usually apply to independent contractors. Okay, for instance, the first one, employee health and safety training. The second one is clean toilets and washing facilities. And the last one is maintenance of emergency. So the next is, okay, the last reason is, in case of a judgment made against an employee, an attachment of earnings can be ordered. For example, the court can compel the employer to deduct the employee's salary and wages for certain purpose. Okay, for the conclusion is, so the conclusion is, any business transaction necessitates the use of a contract. The second is, in order to hire a third party as independent contractor for a short-term project or purpose, one must have a service agreement. So the third is, a service contract is an agreement between an employer and employee under which the employee performs service for the company on a daily basis. So the last one is, the content of an employment agreement varies by industry. and describes the type of work the employer will be doing. So that's all from us. Thank you, sir, for spending time with us.